It's Wednesday afternoon and time for us to turn our attention to legal matters. This is part of our commitment to putting Southeast Texas first. We like to ask the judge. So we're joined this afternoon by Judge Randy Shelton from the 279th District Court in Jefferson County. All waves, Judge. Hope your week's going well.
Yes, it's going great.
All right, let's get to it. This first question from a viewer who says, help, my landlord is telling me I have to move out in 4 weeks because they're selling our building. I have 6 months left on my lease. Surely this isn't allowed.
It probably isn't allowed, but check your lease. If there's a clause that allows the landlord to end the lease early for some reason, then the landlord might have that right. But otherwise, the landlord cannot sell your right to occupy the apartment out from under you.
Okay, good to know. Seems fairly simple, so double check what's in the lease. This second question from a viewer who says, what happens when an executor of a will does not respond to others listed in the said will? It's been over 3.5 years. Lawyer was retained and letters sent, but still no response from executor. We think all the estate has been stolen. Help. Thank you.
Well, the executor of a will owes a fiduciary duty to the heirs, and a fiduciary duty is a high degree of responsibility. An executor must put the interest of the heirs ahead of his or her own. If the executor has mismanaged the property or used the property for the executor's own benefit, the executor could be removed as the executor and held civilly and criminally responsible for any misdeeds. Heirs might need to hire an attorney with experience in probate law to investigate and bring any improper action to the attention of the probate judge. And one last thing, if the executor has not probated the will, your attorney could force the will to be probated. And then once it's probated, the judge will ensure that the terms of the will are honored.
Wow, 3.5 years, certainly an exceedingly long time to wait for something like that. Frustrating, we understand that. This final question, this person says, one of my neighbors passed away a few years ago. Although deceased, the deed to the property remains in the neighbor's name only. The property is run down, the house needs to be demolished. She says squatters have been allowed in and out, and law enforcement's been called to the property on numerous occasions for illegal activity. The heirs still live in the area and are aware of what goes on there. What can be done to alleviate this problematic property?
Well, first of all, no heirs want to claim this property, probably because of the cost of maintaining it or removing it, and probably there's taxes owed on the property. But take pictures and videos of the condition of the house and of these squatters and report the condition to the local building code enforcement agency. The city or the local entity can maybe take some action to kind of resolve that issue. The only other option, and I hate to even mention this, is that you can hire an attorney to sue. First of all, you got to figure out who the rightful owners are and then sue the owners for maintaining what is called a common nuisance. And again, I hate to bring this up because it'll probably cost you money and it's a long shot at best.
Well, those are two options at least, which is better, I guess, than staring at the problem property. So hopefully to our viewer, that helps a little bit.
I hope so.
All right, Judge, thank you so much. Friends, if you've got questions for the judge, go to 12newsnow.com/askthejudge, and there's a form you can fill out right there.